So it's Sunday night and I'm here at home, but I wanted to get a video up this evening so that all you folks that are out there and concerned about what's happening in foreclosure in the state of Florida will take action both this evening and all day long tomorrow and contact the members of the Senate Banking and Insurance Committee and urge them to vote no against the Bill 1890 that will come up before them in a special meeting late Monday afternoon. Now, it's important to note that this legislation, as it's currently drafted, won't do much of anything to address the persistent problem of foreclosure that exists in the state right now. And that should be the starting point for any discussion. You know, doctors say that their first rule is do no harm. And legislators should likewise take that admonition to heart. And the problem with this legislation is first that it will not do anything or next to anything to address the significant problems that exist in our court systems across the state of Florida. And more disturbing perhaps is it could potentially do some damage by increasing court times and could have some really negative unintended consequences that I'm quite certain most folks haven't thought about yet. One of the very, very bad problems with this bill. In fact, there are two versions. One apparently is an amendment by Senator Richter, and the second is an amendment by Senator Haynes. But the Richter section, which includes finality of foreclosure judgments, I know that this is the big push by the title industry. They want our legislators to pass a law to essentially grant them immunity for the wrongful conduct of all the agents that they had out there engaging in grossly improper behavior and practices for many, many years. That's a big part of the reason why our courts are clogged up right now, is because the foreclosure mills and the banks have gotten caught engaging in what is on a spectrum from grossly improper practice to document errors, if we want to be charitable, all the way towards criminal conduct. We have to be clear about this. Forgery can be a crime. Violations of notary laws can absolutely be crimes, up to felonies. And, you know, in this country, and particularly in this state, we are trying to dance away from this very real reality, is that people committed crimes in their attempt to push through foreclosures. What this finality of foreclosure judgment seeks to do is to absolve all of these parties from their complicity in what are some serious crimes, number one. But let's talk about a very real potential unintended consequence, and I would dare say it is a very real consequence that's going to happen. If you tell judges that once you make that final judgment, there is no turning back, a homeowner can never get that property again, I promise you that our good elected judges who are thoughtful judicial officers and have sworn an oath to a constitution, they will take a second thought about granting foreclosure in cases when there's a question mark. And so I know that this provision in the bill, which seeks to make final judgments foreclosure, is being pushed very aggressively by the title industry. It's wrong on public policy ground. The title industry accepted the risks that they got into when they started with these title agents, these foreclosure mills that were engaging in these bad practices. They wrote the title policies based on that. And so they shouldn't be given a free pass. The suggestion that somehow the claims would be turned into a claim for money damages and that might be sufficient is absolutely not true at all. So many of these plaintiffs are shadow, ghostly plaintiffs that if there ever were a claim, they would just evaporate and disappear. So if the Senate passes this version and makes foreclosure judgments final, they need to understand that what they're doing is giving the banking industry and the foreclosure mill industry a free pass to take Floridians' homes from them, and that the Floridians won't have any redress for their rights. Now, we have to be mindful of the fact that we're dealing largely with the Republican constituency here, Republican senators. And, you know, one of the things that's so frustrating in this country right now is the Republicans had an ideology that respected private property rights, that respected contract rights and the rule of law. But what we're seeing in the Republican Party, and it's exemplified in Florida, is that that core value, those key principles that said we respect private property rights and we respect contracts, is no longer being respected by the Republican Party. And if they choose to pass this bill, which would abrogate the contract rights of mortgage holders and property owners and title insurance companies, then they need to accept the fact that they're doing so in violation of their own key principles. Now, There are also many constitutional principles that come into play here. I was very encouraged, obviously, to see the letter from Henry Trawick. I would encourage everyone to read that letter and understand exactly what it says. He makes it clear that there are some potential constitutional problems in this bill that our senators, particularly thoughtful senators, need to understand. If you pass this bill that does have potential constitutional consequences, it's going to be far more damaging in the long run. You know, politically, what our elected officials need to understand is that the population is very upset and angry, and frankly, rightly so. They're tired of seeing again and again the banks and institutions live above the law. And what would happen if this legislation passes is our voters, our constituents, would once again be treated to another example of the banks getting a free pass. And it's yet more proof that there is a dual standard out there. There are a set of laws and rules that apply to you and I, normal citizens. But the banks and institutions, when they don't see things going their way, are able to petition our elected officials who are supposed to be working for us and convince them to change the law to make what was illegal legal. So I encourage every single one of you to take the time today and all day tomorrow on Monday, email the senators, call their offices, and voice your very strong opposition to Senate Bill 1890 and either one of the amendments, but particularly Senator Richter's amendment, which has this finality of foreclosure judgment provision in there. If this passes, it will be a sad day in the state of Florida because it would represent a slide back and frankly, a diminution and a destruction of private rights and a desecration of due process and constitutional rights. So I hope all of you will take the opportunity to get involved, write your senators, call them. It's the Senate Banking and Insurance Committee in particular that you need to focus on, and just tell them that you want to support the rule of law and support homeowners and their rights. Now, what's the alternative? The alternative is, frankly, a good, strong Republican solution, and that is let the market settle things. You know, there are approximately 371,000 foreclosure cases pending in the state of Florida right now, and if they would simply work with consumers, short sales could happen. They could get homeowners in there that have modified them. The vast majority of cases that the homeowner have walked away from, again, the law as it exists will permit them to get those foreclosures done without much trouble. So we need to let the market take its course. And for those cases that the plaintiffs have made such a mess of, the fix on it is frankly quite simple. They dismiss the case and they refile it, paying a new filing fee, which will give our court system much needed funding and frankly is a very reasonable a penalty that the banks should pay for clogging up our court systems with junk and detritus that they can't get out, and that's their own problem.